Good afternoon, everybody. Well, hold on a minute before I get started. Okay, I'm going to go ahead and get started now. Let me give me a couple minutes. Um, I want to log into Canvas. It may take me a minute or two to do that. While I'm doing that, I want to remind everybody that this is a live class. It is being streamed on the class YouTube channel. It is recorded there for students to view 24/7 and can hopefully review if you're not here live later on. I do encourage you to do that. Obviously, if you're not here and you're not reading it or not watching it, then it's falling on deaf ears. But regardless, glad for the student who is here, and hopefully this will be of some benefit to you. As another reminder, this is the second of three pre-final exam Zoom classes. We have the final Zoom class will be a week from today, same time, same place, and and it will cover employment law as well as any final questions that you may have about the exam. It is on Monday, December the 8th at 12 o'clock, and at Wednesday, December 10th, we have the final exam. The final exam being uh, covering contract law and employment law. I have it mostly written, not completely. I guess I need to get on the horse and get it finished. I have 90% of the contracts portion of the exam written, so I feel pretty good about that. And for today's purposes, I think that we're in good shape for that. Okay, I'm going to do a couple of things today. First thing that I'm going to do is I'm going to share one screen that, let's see, share. I'm going to share that one. Okay. Um, By the way, ignore the title here. It is not a comprehensive study guide for contract law, not at all. Instead, I dictated what I had on my chicken scratch writing. I, I love that comment that one of the students had uh, on the survey about the course, and where they remarked accurately, very fair, that my handwriting was like a doctor's chicken scratches. So they asked that I type those things out. So basically, this is what this is. I dictated it, and it threw it into an AI device, and it sort of created this outline. The title is not accurate at all. It is not a comprehensive study guide for contract law, but it does have some of the key elements that will be on the exam that I think you need to be aware of for purposes of the exam, and some of the more difficult areas. Some of the easier ones I don't bother to even mention because I do think that it is easier. You will need to know things like, how to form a contract, and it doesn't. It sounds easy to begin with. People say, well, you just sign it. Well, it's not. In real life, there are many, many cases in the courts where that was at issue. Was there a valid offer made? Was it a real offer made? Was it made with the real intent to make an offer? Did it have the requisite requirements for a valid offer? Was the subject matter legal? Was there an acceptance of that offer? Was the acceptance, was there a revocation of the offer before the acceptance. And that has there's a lot involved in the mailbox rule on that one. There's mailbox rule has to do with an offer that was made. It's a valid offer, and then there's a an acceptance that takes place, but there's also a revocation. And the question is, which came first, the chicken or the egg? Which came first, the acceptance or the revocation? And there are specific rules related to that apply even today. I know today we mainly use email and things like that, but not always. And in fact, many times there can be some issues with how offers are communicated, how acceptances are communicated, and what happens when they are accepted in a way different than the way the offer required them to accept. Is it still a valid acceptance? And the answer is usually it is, but the timing of it may change with that. What happens when somebody says, yeah, I'll accept that offer, but you got to do this or that or whatever, um, I'll buy that horse from you, but you got to throw in that saddle, or I'll buy this car from you, but you've got to throw in this the little scooter that you've got as well. What happens when those things occur? Is there an acceptance, or is that a counteroffer? And what's a counteroffer? But what does that mean? Does a counteroffer destroy the original offer? If it does, then can you come back later and accept that offer? Okay, well, you won't sell me the car without the scooter. Well, I'll still take the car. I'm fine. I'll do that. Do you have a contract then? If you don't have a contract, what do you have? And the answer is you've got a new offer with that. Um, Contracts, voidable, or valid, and those are things that can be very tricky for students. Uh, if a contract is, I've seen this a lot over the years in terms of uh, having a statute of limitations, credit card company turns over a unpaid credit card debt to a collection agency. And the collection agency is trying to collect years after the debt took place and actually after the statute of limitations. Is it a valid contract that still exists, or is it void? What about someone who is under the age of 19 in Alabama or under the age of 18 in other states and they are a minor? Can they enter into a valid contract? They can, but is it a valid contract period, or is it a valid but voidable contract? And what does that mean? Um, what about if someone lacks capacity? They have some sort of defect where they're mentally incompetent. Is it a valid contract, voidable contract, or void contract? And the difference, and it actually can be all of those, or any of those, I should say. The contract's either going to be valid or valid but voidable, or valid or void period. And it's going to depend upon, what were they legally declared mentally incompetent? And that leads to one conclusion. Were they not declared mentally incompetent, but they are mentally incompetent and they don't understand the nature and terms of the contract? What does that mean? What if they're not declared mentally incompetent by court? Well, that's what I mean when I say mentally declared. What if they're not mentally declared incompetent, but they are mentally incompetent as a legal matter, or as a medical diagnosis, but they understand the nature and consequences of that contract? What does that mean? What are the rights of the parties in that situation? Mistake. Need to look and be careful about mistake. What happens when the parties, because a lot of times people say that a meeting of the minds is required in order to have a valid contract. That's why you call it an agreement, right? Um, the parties have to understand each other and agree upon something. Well, what if there's a mistaken impression about something or another? And it could be unilateral, meaning on one side, the seller didn't understand something that was part of the agreement, or the buyer didn't understand something that was part of the agreement, but the other side understood. Or it could be bilateral, where neither side, or where I should say both sides are mistaken about something. I'm going to sell you my live horse, uh, Freda, and Freda is not. Freda had died of a heart attack that morning. Both sides thought they were dealing with the sale of a live horse, and it turned out the horse was deceased. Neither side knew that. What happens when it's a bilateral mistake? And you need to know the consequences of that. How long, kind of jumping back on the offer, somebody makes an offer, how long does that offer stay open? Um, if I say that I'll sell you a car and the sale price of the car is $5,000, and but I have to hear by 5 o'clock today, and at that point, I'm going to withdraw the offer and it's going to go to somebody else. Well, that's easy. The offer is open until 5 p.m. Why? Because that's what the offer said. But what if the offer doesn't say anything? How long does it stay open? And the answer is right there. It's a reasonable time. But what's a reasonable time? Can it be revoked during that time period? And you need to know the answer to that. Subject matter needs to be legal. If it's not illegal, if it's not a legal subject matter, then the contract's not enforceable. Consideration. This is one I try to emphasize it, but for some reason students still struggle with this, and this can be very, very important. Uh, I always like to give the illustration about even a mere peppercorn can be sufficient consideration to support a contract, and I liked that, number one, because Professor Saul Litvinoff used that when I took contract law class in my first year of law school many years ago, and and it really resonated with me, and so I imparted that upon my students ever since. But it also points out something that I think is very important, and it's an exaggeration to some degree, but it's pointing out, peppercorn is just the thing that's involved in that grinder where you're making pepper with that, and basically what it's saying is, look, we're not looking for much, but each side has to get something. If I'm selling you my car for $5,000 and it's worth 500, and you pay me 5,000, you say, wait a minute, it was only worth 500, and you file a lawsuit against me and you say, Judge, it wasn't fair. The judge is going to say, look, that's not my job. My job is to see if there's a contract here. There was an offer made, there was an acceptance made, it's a valid subject matter, um, and there was consideration that flowed between both parties. One side paid something to the other side gave up something to the first one. Something of value passed between each side. So you're going to look for something. Consideration is something. You have to have something. You have to have something sufficient value. Sufficient meaning not necessarily fair, not necessarily equal, but something of value that passes. Even a mere peppercorn can be sufficient consideration to support a contract. Now, one area that I have seen students struggle with is on this concept of illusory promises or uh, past promises or whatever. And I don't recall right now exactly the illustration I gave in the lecture, but something like this. You've got a concert and the they have a company that's going to bring in 50 tons of gravel so that people can park in this area and it's not just mud and whatever. It'll be something gravel. And the concert is on Saturday, December 1 of some year. And on November 28th of that same year, the party that's delivering the gravel contacts the concert provider and they say, hey, I know we got this contract, I know we got this deal, and I told you that I'd have it in by November 30th so that people could park on it on December 1. But, other people have maybe a bit, better offer for the gravel, and I've only got so much gravel, so I'm not going to be able to do that. And, if you can match the offer, you were going to pay me $50 a ton and they're going to pay me $60 a ton. If you can match it, I'll be glad to do that. And you get really mad as the concert provider. The concert provider says, look, um, you know, I don't have a choice. You're the only gravel provider that can put this in by the 30th. Yeah, fine. I'll go ahead and pay the extra $10 to have you put that in. And so they do that, and instead the concert provider pays $50 and not 60. The gravel provider sues for the additional $10 a ton. And if the court's applying the law correctly, they're going to say, well, look, you already had the obligation to provide that gravel to them at $50 a ton. They got nothing additional of value in exchange for their promise to pay you $10 more per ton. Your past promise to deliver by November 30th was not new consideration. It's not valid for a new contract. Now, here's where, and a lot of times students get that, but here's where they kind of foul up. What if instead the gravel provider said, look, we will provide the gravel for you on Friday, November 30th, uh, but we will also provide two people and a skip loader to help spread it out in exchange for you paying, $20 extra per ton. And you, as the concert provider, say, fine. Well, if that's the case, the gravel provider has a good lawsuit against the concert promoter. And why? Because they have given new consideration. They're providing two men and a skip loader to help spread out the thing. And by the way, I'm not a construction guy. I don't know what a skip loader is, so that's probably the wrong thing. But something mechanical to help spread that out. So that would actually be something that would be valid as new consideration, and there would be a good lawsuit to enforce the additional $20 uh, per ton, because in addition to providing the gravel as they had already agreed to do, they provided this new consideration. Was it worth $20 a ton for the skip loader and the two men? Probably not. In my example, let's just assume that it wouldn't be, but it doesn't matter. That's new consideration. Even a mere peppercorn can be sufficient consideration for a contract. So it certainly passed the peppercorn test. Okay. That's all I have on these little notes, and it's not nearly enough. But the other thing that I wanted to do, I'm gonna see if I can pull this over so I don't have to change the thing. I think I can. Yeah, here we go. Let me pull up. Um, I just wanted to be real careful with everyone to make sure that you are studying everything. One of I had, and it always happens like this. I had several students say, "Gee, Professor, we really like the real world case examples. They're more interesting. It helps us to understand the legal concepts better than just reading the stuff on a PowerPoint. Uh, and if there's any way you can do more of those, it would greatly enhance the class." And, then I had one student that said, I don't think it's fair to have um, additional, cases and things that don't do anything more than you just repeating what the PowerPoint slides say. Well, number one, that is never going to be the case. I mean, the PowerPoint slides, I don't even look at the PowerPoint slides. So I am not just reading what the PowerPoint slides say. I'm an old lawyer. I've done this for a long time. I've done with everything that we deal with in class, and for that reason, that's where I teach from that standpoint. PowerPoint slides are helpful. They definitely are helpful, and occasionally I'll pull a test question from there just to make sure that you're reading it. But the one thing that I want to make sure of is you study everything. I had a meeting with a student after the first exam. They said, "Gee, I did poorly on this first exam, and I never do poorly, and I'd like to know why. Let's talk about it." And I said, "Okay, we'll go over your exam." So we're going over the exam, and I said, "Here's this thing, and this came from this handout." And the student told me, they said, "I didn't read that handout." Read everything. Watch everything. Every single thing is important. I will pull a question from anywhere and everywhere. There's no homework in this class. Your homework is studying the material, reading all of it. Again, I'm not trying to make this a law school class. I mean, for a class, we'd have 100 pages of reading a day. Just, we were required to read, but that's law. That's part of law. So you don't have 100 pages to read every day. I don't do that. And a lot of the material that I have is lecture based. So all you've got to do is watch and listen to the lectures. And I highly recommend take notes for those lectures, just like you're sitting in a class, and then study what you have heard and seen and read. So that's what I want to do. So I want to come over here to the modules and just make sure that you are uh, that you study the correct material. So you come up over to modules, go all the way down to contracts material on final exam. And I rearranged this a little bit. Initially, I had final exam and I had all the contracts material and all the employment law material all jumbled up together. And I decided, let me go ahead and separate this just so that students can watch this and read this and study this more in a segmented kind of way where you spend 2 weeks studying approximately on contracts and 2 weeks approximately studying employment law, and you can be hopefully well prepared. But if you look, we have the contract formation PowerPoint slide. We have the contract breach and remedies uh, PowerPoint slides. Then you have a mailbox rule. Uh, I think that's just a handout kind of thing or schematic that I did. Let me take a quick look and see. Um, yeah, that's a little schematic that I did, and you can see that can be complicated. That can be very complicated with that. And I used old school stuff like faxes and such in order to illustrate the principles. And then you've got the mailbox rule lecture, where I actually talk about that. The contract formation, one and two, breach of contract, and it's three parts. Sorry about that, but those are all lectures that'll be done. And then contract law, important illustrations, and real world principles. These are all short videos. They're important short videos, but they talk about different things, including a couple of new, or at least one new area that's not in the PowerPoint slides at all, which is interpretation of the contract, the four corners of the contract, and what happens when a provision is ambiguous or vague. You need to know that. You need to watch all of those. And again, these are short. I think they're 5 to 10 minute videos. There might be a 12-minute video in there, but it's short. I think the all five of them are going to be less than an hour, but you need to study that. When we get to employment law, and I'll try to remind you on that one as well, but you'll have different things there, including the employment law, important illustration. I think there's only two that I've done. I'm not going to add any more. Two more that are there, and you need to study those as well. So anyway, the as I said, approximately half the final exam is going to be contract law. Approximately half will be employment law. It may be a little different than that. Don't hold me to that specifically. You might have 60% on one and 40% on the other. It won't be any more than that, but I think it's going to be pretty close to 50-50. Um, so far, I have some questions that are true, false, and I have some questions that are short answer or I even hate to call them essay. Every single question can be answered in 2 sentences. It doesn't require uh, much, and if it's more than 3 sentences, you're doing something wrong. In fact, what I'm going to do is I want to tell you if you, I call them vomited answers, where you just kind of vomit everything that you know about a particular subject on an answer. That's telling me that you're not really grasping the idea of law. It's very important in law to be concise, to understand what the issue is, and to address the issue, and not just a whole bunch of other garbage that's out there. And just being speaking frankly, the AI answers provide vomited type answers. If I get vomited type answers, they get 0 points. They get no credit on the exam. So make sure you understand what it is that I'm asking and answer that question. Um, okay, that's all that I have for what I wanted to cover for you today. My student that is here with me, if you have any questions that you would like to ask that may be of general interest to everyone, feel free to ask now. And I'll turn it over and wait and see if you have any. Not hearing any, not, let me see, let me check the chat box. Chat box might have something, I don't know. No question. Okay, great, great. Well, thank you so much for being here. I will have another one of these, the final one of the semester, next Monday at 12 o'clock noon. Be looking for the announcement, the invitation link on your announcements. Um, Having said that, if you have any questions or if there's anything I can do to help you, don't it doesn't have to be during this session. You can uh, usually, if it's something that's going to require any explanation, text message just doesn't work. But you can always text me and say, "Hey, I got a question. Can I, call you about it? Can I email you? What?" Or you can do it on the text message, and I may say, "What's your email address?" I'll drop you an email, something like that. But if there's something I can do to help you, please let me know. Don't forget I think there is a bonus opportunity if you haven't taken it yet. Uh, that is, I think it's going to expire next Monday or something like that. There might be one more that comes this week. Be looking for it. I don't know that there will be, but if there is, I'll post it on the announcements and you'll check your email. Otherwise, y'all have a great week, and I will see you a week from today.